moving from the regional to the global, we have Dr. Yves Remy, who is an expert on World Trade Organization. She was a member of. She was the legal officer with the appellate body Secretariat of the WTO in Geneva before joining Sidley Austin. And we're very lucky today to have her expertise in the area. And thank you very much.
Hello, good morning, good afternoon, everyone. It's such a pleasure to be here. A couple of months ago when I got a call from Petra about appearing here and speaking a little bit about my expertise and adapting them to the small state context, I was really excited. Why? Because up to 2 weeks ago, I attended a conference of the WTO where, after 20 years of existence, well, 21 now, they were celebrating dispute settlement and looking at the milestones achieved in 20 years of the development of jurisprudence. And the one thing that actually occurred to me was there was very little emphasis on small states, developing countries, and in particular, Caribbean small states, where I'm from. And so this is a great opportunity for us collectively as a group to think a little bit about small states and their participation at the WTO. And because my expertise are in dispute settlement, I'm skewing this presentation a little bit to look precisely at how small states have fared in WTO dispute settlement. So I'm taking poetic license. I was given a huge canvas to select a topic. And so what I'm going to look at is how small states, through what I call an SVE, small vulnerable economy vehicles, can advance and enhance their participation in WTO dispute settlement. I must admit, my practice, I'm now in Washington, D.C., which might explain a little bit my jet lag. My practice is not focused exclusively on small states, but I think I'm in a really good vantage position because one of the cases that I actually litigating currently involves a small state. In fact, two, Cuba and the Dominican Republic, against Australia in this huge plain packaging dispute. I also worked at the WTO Secretariat at the appellate body for up to 6 years, where I witnessed small states and their marginal participation in the WTO. And finally, I did a PhD, and David was one of my supervisors, on the Caribbean Court of Justice. So I think even though my practice currently doesn't focus on small states, I'm in a quite advantageous position to look at how small states fare in international dispute settlement. Moving right on. Oops. So what I'm going to cover in the next 10 minutes, because as David explained, we were given quite strict deadlines for our presentation, and please feel free to jot down questions if any of these areas are not precisely enough explained. But I'm going to look at 3 areas. I'm going to look at what are small and vulnerable economies, which I refer to as SVEs, and how have they been accommodated and definitionally understood in the context of the WTO. Secondly, I'm looking at why. Why in the context of WTO dispute settlement do they deserve special focus? And then thirdly, I'm going to look at how, which is always the most difficult. So looking at the case for small states receiving special treatment and then translating that into tangible ways in which we can promote small state participation. So 3 main areas of focus. So the first area I'd like to look at is what is the SVE agenda? And I think there's been a little bit of a discussion here already about definitional issues. In the WTO context, luckily, that has, to a large extent, already been dealt with. SVEs are understood as a category or subcategory of developing countries that have particular concerns in the WTO space. A mandate was created in 2002 called a work program for small and vulnerable economies. So that already advanced a little bit the cause of small states in the WTO space. The problem was that there was a little bit of a whammy in there. It was agreed that although small states could get special attention, there was not supposed to be a formal subcategorization created as a result of the added attention that small and vulnerable economies would actually get. So you're walking a little bit of a tightrope in understanding how to advance their interests in the various negotiating fora, while at the same time not seeking to establish a subcategorization of states. Now, among these proponents, they call them, of SVEs, are, I would say, about 26 countries who more or less align themselves based on based on their common characteristics, which are trade-related, which relate to things like high transportation costs, particular vulnerability to external shocks, particular openness to trade, and which means that they can be very detrimentally impacted as a result of trade and international trade phenomena. And usually their export base is concentrated to very few commodities or services in the case of some of them. And they basically, I'm going to move to this slide, they basically sort of transcend geographical space. So if you look at those that are actually reflected in this presentation, and unfortunately this is the best I could do, a lot of them are concentrated in island states, so in the Pacific, in the Caribbean, and some of them are in Latin America. So we have Panama, we have Guatemala, very small states, basically a function of their size, and I don't think that's particularly useful in the WTO context. It's much more a function of their share of international trade, which is understood as usually less than 0.5% of international trade. Now, the way SVEs have been pursuing their negotiating mandate is very theater-specific. So what they've tried to do is, in the context of specific negotiations in these areas, agriculture, market access, fishery subsidy services, and trade facilitation, is to carve out themselves as deserving of special attention without, as I mentioned, creating this formal categorization of states. So they've managed to press their issues by explaining why their vulnerability to trade requires them to get some special dispensation in the rules in these various fora. For me, the most lacking area currently that has been understood as part of the SVE negotiating mandate is in dispute settlement, and the rest of my presentation will look at that, because I think actually dispute settlement is a hugely vital area for SVEs to carve out space for themselves, and I'm going to explain to you why. There's been a lot written, and there's somebody here from the Commonwealth Secretariat. There's been a lot written by people like Stephen Favrier from St. Lucia about SVEs and their specific role and their specific negotiating mandate in all of these areas. Separately, also financed by the Commonwealth Secretariat, there's been a lot written about the importance of developed Commonwealth states and their participation in the WTO. But the two have not been merged yet, which is how to use that SVE vehicle that is already established as an advocacy framework with the special needs of developing countries, small developing countries, in dispute settlement. Why do SVEs deserve special treatment in dispute settlement that is separate and apart from other developing countries? And those of you familiar with WTO dispute settlement will know that there's always a hurdle of explaining why you need special dispensation, why you need special rules in the context of the negotiations. And in my view, there are a couple of reasons. In fact, I've itemized 4. The first is that there is a unique profile for small states and small vulnerable economies in the dispute settlement context. And the challenge, I think, in moving this suggestion that I'm making forward is to link vulnerability to the dispute settlement context. So explain to WTO membership why these SVEs are deserving of this special treatment. Now, somebody mentioned in the previous panel that it would be a mistake to expect or to portray a homogeneous approach among different SVEs to any issues that arise in trade, and that is particularly true for SVEs. I didn't mention exactly which countries these are, but I think I showed you. There's a wide range of profiles among developing countries, among SVEs at the WTO. You have countries that are not very litigious, and their participation is really as third parties, predominantly CARICOM countries. But within SVEs, you also have hugely litigious countries in Latin America, from Latin America. So you have countries like Guatemala, Honduras, Panama that are featuring very prominently in dispute settlement. And they are actually pressing issues that are receiving a lot of attention. As I mentioned, plain packaging, the DR and Cuba. Panama recently got dealt a blow by the WTO dispute settlement as a result of the financial services case that they brought against Argentina for Argentina's treatment of them as non-cooperative tax jurisdictions. So they are featuring highly there. Why do I think that nonetheless, despite this diversity of participation among the subgrouping, is there a common cause? The common cause arises from the fact that these countries are hugely impacted by the decisions in which they participate as disputants or as third parties. So what unites them is the fact that although selective in the cases they bring or they defend, the impact, because of their narrow base of production and export, is hugely impactful. They're different from LDCs because they are actually using dispute settlement, as I explained, as a way to enforce rules. So they have an interest in the system. The problem is that they're not necessarily yielding the best results from dispute settlement, and I'll explain how they can do that better. The second reason that I think hugely militates in favor of dispute settlement being a priority of SVEs is that usually you hear, oh, we're not that big, we don't participate hugely in trade. Trade is not that, dispute settlement is not something we can afford. Unfortunately, or fortunately for small states, it's not an excuse that we can run with anymore. A lot of the decisions that are taking place and impacting the negotiations are being fomented in these disputes. So for instance, you have a lot of disputes being settled relating to SPS standards, climate change, and renewable energy. Renewable energy is a huge area being discussed now in the context of dispute settlement. What kind of investment regimes can countries put forward in order to promote investment in renewable energy sectors? Financial services, what kind of prudential regulation can countries actually execute, even if it might have a trade impact? These are things that affect small and developing countries disproportionately. And so we're moving beyond a concern with just commodity items where you had the bananas and the sugar rulings to really hugely important decisions taking place at the WTO. And the reason that this is so important is because we know what's happening in the Doha negotiations. There is a stalemate there. So what you find a lot of countries doing is pressing now their issues in the context of dispute settlement, and small states cannot afford not to participate in these discussions. Judicial enforcement, I propose, is a viable alternative as an offensive trade policy tool. So we have these rules negotiations that have been taking place and laboring for years and years and years. If small states can find a way to position themselves in the context of disputes and ply their case there, that I think is a viable alternative to sitting in Geneva and trying to hammer out rules, especially in new areas that are not going much further than where they were 10 years ago. I think another important point is, although you don't find many cases where developed countries are actually bringing cases against small countries, nonetheless, the fare of dispute settlement will act as a bulwark in preventing bigger countries from taking trade restrictive measures that influence and impact detrimentally on small states. If they feel that they can do so with impunity, impose SPS measures, what I mean by sanitary and phytosanitary measures, or promulgate technical standards that are extremely trade restrictive and impact developing countries and small developing countries, they will do so willy-nilly. We need to have in place a system where they know that they will be brought to task under the WTO. even by small and developing countries. And finally, Julio Lacarte, who is understood as one of the forefathers of the dispute settlement construct at the WTO, once said that the dispute settlement mechanism is the one place where right perseveres over might. And if small developing countries cannot press their case for the imbalance in the trade rules being righted in the context of dispute settlement, I don't know where else we have a better sounding board. So this is an area where I think advocacy-wise, we can use the trade mantra, the dispute settlement mantra, that this is where you equalize opportunities for small states. I think that's a good place to start. Now, how, as I said, the really difficult point now is moving from an awareness of the small state interest in dispute settlement to practical solutions of how we can actually get this done. And as a practitioner and as a witness to a lot of the ways that I think we can do better in that arena, I'm going to propose two main sets of changes. I think another speaker, is it Baldur from Iceland, said that there's almost like a twin dynamic that we have to be aware of. One is how you change the rules from the outside, or how you advocate the case effectively for rule change on the outside. But also a lot has to be done in terms of improving capacity, but also improving structures on the inside. I'm going to start with changes to the rules themselves. My number one point has been we need to increase the awareness, create that space around ourselves as small, vulnerable economies in the context of the WTO. And I think a lot has already been done in the other contexts, in agriculture. So the path, for instance, has already been laid. And all we need to do is to add to the mandate of small states and small, vulnerable economies a dispute settlement vehicle in the context of the ongoing negotiations for DSU reform, but also, so at the WTO, there's been for the past 15 years discussions about how to transform the rules of the dispute settlement system to accommodate better the concerns of members. And SVEs are noticeably lacking there. Although they have had experience using the rules, there is no coherent, systematic approach to using these negotiations in an attempt to advocate the position. And I think the position as SEs has to be technically sound. So we have to do a proper study, critical study of how SVEs are particularly impacted by dispute settlement and dispute settlement rules, and then from that basis, press the case for enhancing our participation through adaptation of the rules. And there are a plethora of ongoing proposals being negotiated at the dispute settlement stage. So my proposal would be to critically assess what is already on the table and see how we can use them to our advantage, sign on to those that are actually in our favor, and reject those that are not. So for instance, a very clear, easy example, a huge problem for SVs is access to the system. Access meaning because we're such limited resources countries, we cannot attend all the meetings in Geneva. We cannot necessarily have the best law firms, the most expensive law firms participate. We need to develop units in each of our ministries, and this can actually transcend geography. There can be a unit set up, for instance, in the Commonwealth Secretariat that thinks through how SVs are impacted by the dispute settlement rules. So for instance, as I was saying, enhanced third-party rights. Because we should be participated in the disputes as third parties, we should be monitoring these on a consistent basis and reporting to the membership, the SVE membership, on how these impact our trade policy. And then on the other hand, and I'd like to talk a lot more about the changes to the rules, so if any of you have questions, I'll take that up in the Q&A. But more, I think, something that will empower us even more is internally to execute and implement changes to the actual practice of how we engage in dispute settlement. We need to make, first of all, strategic choices on the cases that we bring. Naturally, there's a filter, I think, to the cases that we bring, because SVEs will only bring cases that they actually think they will win, usually. This is actually documented and empirically tested. And also, you might think, and this is going to be a hugely, I think, this is very controversial, a lot of interests, so hugely important multinationals, are accused of using small states to ply or pursue their interests at the WTO. So for instance, in the context of the gambling case, you heard in the corridors, is this really of interest to Antigua and Barbuda? In the context of the plain packaging case, you hear, is it Philip Morris or the Dominican Republic that is actually bringing this case? And I think that's going down the wrong road. I think developing countries, small developing countries, often have an interest in their cases being financed by these multinationals where the interests actually align. My biggest problem is that we're not making sure that any of the experiences that we have being funded potentially by bigger interests don't then go onshore to improve local capacity in these countries. So whilst the experience is very important to small and developing countries, what is happening in terms of, after these disputes, what is happening in terms of the manpower and the ability of persons in ministries and trade ministries to bring a case themselves the next time? I think that link is not happening enough. Use free resources strategically. There are lots of ways that we can use the SVG agenda, for instance, to ensure that there is effective capacity building in these countries as third parties participating more often, because what you find is that even in countries where, like Antigua and Barbuda, that brought cases to the WTO, no CARICOM country supported as a third party. And so we're not being strategic about endorsing the countries that we have a share and interest, even in the region, in bringing a case with, and we're not using the mechanism of the dispute settlement to learn how to play by the rules through third-party participation. And finally, because I know I'm running out of time, I think we need to move beyond as third parties and as, especially as third parties, and especially in terms of what we offer to dispute settlement, atmospheric and what I call backseat participation, to actual active and effective participation. What do I mean by that? When you hear at the DSB meetings and when you hear the character of the interventions that small states make in the context of disputes, it's often confined to factual overviews of how this dispute is going to affect the economies, it's going to be catastrophic. I think we need to move beyond that, which is important, to understanding the rules among the people in the trade ministries, capitalizing on persons, and I'm going to say it like myself, who are engaged in trade dispute settlement, and make sure that the people in the ministries understand how the rules work, understand how to frame the debate in legalese that's going to ultimately make a difference in the outcome of the disputes. And I think we need to get engaged more actively and effectively in how to understand, how to interpret, how to promote interpretations of the rules where there are gaps in the rules to our benefit. And so I think that the nature of the participation of small states has to improve and has to increase. And the others, I think, are self-explanatory. So just in conclusion, and I know I've overstepped my 10 minutes, but I think the case has been made in the last 10, 15 minutes to identify that there are unique concerns among non-homogeneous, but among all of the states of the small vulnerable economies, there are unique concerns that warrant attention at the WTO. We cannot afford as small states to rest on our laurels or sit on the sidelines. We need to think strategically about how to move from non-active backseat participation to frontal insertion into the debate taking place at the WTO. And I think because a lot of the ground rules have already been established and there is consensus among the membership that SVEs deserve special attention, the SVE vehicle is an effective way of making our concerns heard through dispute settlement. Thank you very much.
Well, I'm sure that will stimulate a lot of questions at the end. I've no doubt about that. Champerty and maintenance in Geneva.